I'm well, Jacqueline. How are you doing?
I'm doing great, thank you. Well, like I mentioned, we had a lot of questions that came in, and some of them we had an opportunity to look at ahead of time. Some of them will come in as we go along. But, I think one of the first things that people want to know about is all of the mandates and information that seems to be changing. So can you give us an update on the shelter-in-place laws?
Sure, Jacqueline, I will, and I will tell you this is a confusing issue for a lot of people, partly because there are so many different laws in place from across the country. From the federal government has their own mandates and own directions out, and then within the state of Texas, you've got the governor's office coming out with requirements. You have the various counties and the cities within the counties coming out with requirements, and they're not always the same. So there's a lot of confusion in this area. And since we last had a webinar last Friday, excuse me, there's actually been a lot of changes to these rules. Just for starters, 2 days ago, this past Monday, President Trump extended the social distancing guidelines until the end of April. Not only did they extend the guidelines, but they also made them more restrictive as far as social distancing requirements and any type of public gathering. And from that, you've seen a cascade of state and local governing bodies make changes to their rules. And so Texas has not been any different. Texas has expanded their rules. Last night, Governor Abbott's office extended the social distancing executive order that the governor put in about 2.5 weeks ago. This extends through April 30th. The Governor Abbott was very, very articulate about stating that this does not put a statewide shelter-in-place order in effect. And he said that because there's been a lot of pressure on the governor's office to do that. But then he went ahead and said that this does bring Texas in line with a lot of the other states who are doing similar things. So possibly a political statement mixed in there, but no surprise coming from a politician. In any event, the Texas guidelines talks about certain essential services that may still continue. Some that are critical for landlords, for example, specifically for landlords, any critical manufacturing can still continue, as well as allowing to facilitate commercial facilities such as office buildings, retail buildings, etc. And this gets confusing because you might, for example, have a retail building or a shopping mall, and even though most of the tenants in there are not considered essential services, allowing the landlord to still maintain that asset and have the property manager still maintain that asset is still considered an essential service. Does that make sense?
Yeah, it does. If I can ask you a question, if there's a industrial building, and let's just say it's a single tenant building, maybe it's 100,000 square feet. Of course, the landlord manages it, but it's only occupied by that one tenant. And this tenant, manufactures clothing. I mean, how is that considered?
Well, so the landlord itself would still be able to whatever obligation the landlord has under that lease. For example, let's say the landlord's obligation is to maintain the roof, and suppose it's springtime in Dallas, weather is fairly lovely depending on the day, and if there's some rain and it's leaking through the roof, if the landlord is obligated to fix that, the landlord should still perform its obligations under the lease. There's nothing in the shelter-in-place laws that stop that. And that's regardless of whether or not the tenant is in there and operating. So the tenant may not be able to get in there to notice that there's a leak. And so now the question is, well, how do we know if the landlord it can't get notice from the tenant because they've ceased? Well, the landlord still has a lot of this depends on the lease, but landlord still has a duty to make sure that the asset is being taken care of, especially if they know that the tenant's not out there.
Yeah. And just kind of to go back on what the governor has now put in place through April 30th. So that effectively, because Dallas had a shelter-in-place order, I think it was through.
It's through April 3rd, this Friday.
Yeah, but now it is effectively now extended till April 30th as well.
Well, there lies the confusion because when Dallas County Commissioner Clay Jenkins on March 24th issued his order for the shelter in place, he took that through April 3rd, and so you can certainly certainly have to comply with the state order, but Dallas County's order has not been extended. I'm surprised, frankly, that they have not extended that. I know that there's been some discussions from not only from Commissioner Jenkins' office, but also from the city mayor's office, City of Dallas mayor's office, about making extensions. And I'm sure that they'll do it in due time. They just haven't actually gotten to it. But yes, you would be covered by the state's revised executive order.
Okay. Yeah.
Correct. And another question that came up a lot was the question about evictions. There seems to be a lot of confusion about whether or not a tenant can be evicted right now. There's no confusion about residential tenants. The state Supreme Court came out and they put a halt to all residential evictions. Okay, so there should be no question about that. What gets murky is whether or not you can still proceed with a commercial eviction. There is no statewide prohibition against commercial evictions. However, a lot of the different counties are limiting the access to the courts for only what they're considered to be essential hearings or essential proceedings. So, for example, if there's some type of temporary restraining order or some type of equitable relief that's being sought, or if there's some type of domestic issue at play, the courts will hear those. But each county in the state is taking a different approach to what it deems to be an essential hearing. So in other words, even though your commercial eviction may not be stopped from the state Supreme Court, you may not be able to actually get that case heard by the judge, depending on what county you're in. And each county in Texas, and especially here in the Metroplex, seems to be taking a slightly different approach to this. In some of the counties, it depends on when the proceeding was started. So, for example, some counties, if you filed your eviction action prior to the court essentially limiting hearings to essential actions, that can still be heard. But new cases are being postponed or being abated. So that's there is a lot of confusion on that. But I hope I clarified it. I may not have answered the question, but the answer to the question is, you really have to check which county your property is in and which court you would go to if you wanted to have a commercial eviction to see if you can still have that done.
How does that, or does that at all change just the Texas lockout provisions that we have, where we're not actually going to court immediately?
That's a really good question. Texas is one of the only states that gives self-help rights to landlords. So in Texas, and this is important for a lot of managers who may have property owners from other states, because most other states don't have this right. But Texas allows a landlord or the property manager on behalf of the landlord to actually lock out a tenant. There's a specific rule you have to follow. You have to post notice about this, but the law says that if the tenant is delinquent in rent, and I'm talking specifically about a commercial tenant here, if the tenant is delinquent in rent, you can change the locks so they can no longer access the space. Okay, that is a non-judicial proceeding. That is something that you can do without going to court to accomplish. So there's nothing stopping you as a commercial landlord from having a lockout right now. On the residential side, that's a different story. That has been abated by the Supreme Court. So so the answer to the question is yes, you can still continue with the lockout. The lockout would have to the lockout is good enough to get the tenant out of there, but also keep in mind you cannot lock somebody in. So if a tenant has if the tenant's still operating the space, you cannot lock them in the space. It's just those rules don't change from the normal lockout procedures.
Okay, well, that's interesting, and that kind of plays in as we think about some of the other questions that came up. Where I think right now a lot of landlords are beginning to see or get questions from tenants about paying their rent, and if they if they have to pay their rent, or if there's some type of allowance that's going to be made by the landlords because tenants don't have or feel they don't have access to their spaces.
Yeah. Yeah, so this is going to be becoming a huge issue, obviously on a number of fronts, because we've got, there's a social, civic social component to this, where people want to work with each other to allow businesses to get back on their feet again once once this the coronavirus abates and everyone gets back out there, living like they were living previously. So there's a big social component to it. But putting that aside and just speaking from a legal perspective, I think a lot of us who went through the Great Recession and went through this drill as far as giving rent breaks and rent abatements to tenants, I think we learned a lot from that perspective. And what I'm seeing now and what I've been working on with a lot of my clients over the past few weeks is, as these requests from tenants come in, they're taking more of a holistic approach to this. And so in other words, instead of just saying, okay, well, you want 2 months of rent abatement, no problem, we'll just cut your rent in half for 2 months and just pay it back by the year end, no problem. A lot of that analysis has kind of gone away. That seemed to be very popular during the recession that we had 10 years ago. That's not really how it's working now. It's not how I see that happening now. Most landlords are looking at this holistically, and they're basically hitting the reset button on the underwriting process. And so they're looking at this as that this could potentially be a much bigger long-term impact for their asset overall. So they're actually looking and restarting the entire underwriting process as far as the tenant's request. And so this is doing a couple things. Number one, it's putting a lot of pressure on the property managers and the asset managers to go through all this mass underwriting, if you will. So one thing that we're telling all the tenants is, the first thing is we're telling them that, look, you need to be patient with us because there are a lot of these requests. Okay, a lot of tenants will continually reach out and want to know what's going on. They have to understand that there's a lot of this happening, and so the landlord has to. It's not necessarily a first come first served basis. A lot of landlords and property managers are choosing to prioritize this based on the asset and what their biggest risks are as far as losing tenants. So when I say take a holistic approach to this, what I'm seeing happening is a lot of landlords and property managers are asking the tenants, okay, if you want the landlord to take a hit, to take a haircut, or take an abatement, what are you doing for your other creditors? For example, a lot of the discussions I'm having is asking the tenants to send a list of all of their top creditors, including any banks, equipment lessors, etc. And the landlord is saying, well, what are you doing to make sure that you are mitigating your risks with all of your creditors? And the landlords are saying this from a couple of perspectives. One, the landlords don't want to feel like they're being picked on and then the tenant is not focusing on their other creditors. And number two, the landlord is concerned about the long-term viability of some of these tenants. Some tenants are satisfied with just getting a short-term abatement of rent and then hoping this whole thing goes away and we're all good in a couple months. And then a couple months go by, and if that's not the case, the landlord doesn't want to have to revisit this issue because now the tenant situation went from bad to worse because they neglected their other creditors. And so what we're asking the tenants to do is come back to us with a business plan that shows us what you're doing from an enterprise-wide standpoint as far as mitigating your losses, mitigating your damages.
Quick question for you on that.
Yes.
Do you feel like, or do you see, as far as timing, when they're looking at how long they may give these abatements or concessions, is there a time frame you're typically seeing around it?
Yeah, good question. I'm getting a lot of tenants asking for 6-month or even 9-month abatements, and I'm not seeing a lot of landlords willing to do that right now. I'm having a lot of my landlord clients tell me that we may consider that. We'll see how this goes, but we're trying to keep these the rent breaks, the rent abatements limited to a 2 to 3, and some instances a 4-month window. And I don't see a lot of folks on the landlord side looking to go beyond that, just because we don't, so much is unknown right now. So that seems to be what we're seeing right now.
Is this really abatement where they're totally putting the rent at the end of the lease, or is it a forbearance? Are they reducing the rent and adding it to later months? What are you seeing there?
We're seeing a whole mix of things. We're seeing a lot of landlords are choosing to extend out the lease, and then tack it on at some point, either blend it out throughout the rest of the term or tack it on at some point. I'm seeing a lot of other landlords, depending on the tenant, I'm seeing them say, well, if you want a break on rent, I need it paid back by the end of Q3 or by the end of Q4 in 2020, or some type of parameter on that. One thing that you should also take in consideration is, again, just taking this holistically, the first question that we're asking the tenants, aside from how are they mitigating their exposure, is how has this affected you? And some tenants are very opportunistic, right? In the words of Winston Churchill, never waste a crisis. So we've seen a couple tenants try and take advantage of this crisis, asking for rent relief. And when we ask them, based on their use, how are you being affected? The tenants couldn't really articulate how the COVID-19 was impacting their business. Now, some tenants, obviously, on the retail side, if you have restaurant tenants or non-essential retail tenants, it's probably a lot more obvious how the virus is impacting them. But the one thing you want to be sure is that you want to find out specifically from your tenant, and I would get this in writing, how is this actually affecting them? Another issue that we're having our tenants take advantage of, or at least asking them if they've looked into, is a lot of the government relief that's out there. With the CARES Act being going into effect last week, there's a lot of money available to a lot of different types of businesses, depending on how many employees you have, and it's fairly easy. At least it seems like it's going to be easy to get access to this money. And so we are asking the tenants to let us know what efforts they've made to go out and actually get some of that government stimulus money.
That's good.
See a couple of points.
Let me ask you this question about you talked a little bit about questions to ask the tenant. What documentation should we request from the tenants?
Great question. I would definitely ask for, first and foremost, balance sheet, profit and loss statement. We're also asking for a list of the tenant's customers to see how viable the tenant could be based on their customer base, which may not be so obvious. If your tenant has a list of public companies who are customers, then it'd be easier to figure out how those companies are doing. Otherwise, it may not be so straightforward. But we're wanting to see what type of customers they have. We're asking tenants to provide bank statements. We also want to know what type of compensation the tenants are giving to their to either their investors or their top officers. What we don't want is a situation where the tenants are paying huge salaries to the CEO and the other C-level officers, and making big distributions to their investors, and then trying to pinch the landlord for a few months of rent. So we're asking to see distributions that were made to shareholders, investors, and compensation that was made to the especially the top level officers of the company, for definitely the last 3 months, 2020, and some of my clients are asking to see that for 2020 and 2019. Also, as part of the forbearance agreements, or as part of the amendments to the leases that we're seeing, I'm seeing a lot of clients wanting to restrict their tenants' ability to make distributions or to give out big bonuses to their officers. So we're asking to see a lot of that information as well, from more of an HR standpoint. Again, like I said, we want to see documentation from the tenants about how this has impacted them. There's going to be another big discussion of coming in the next weeks and months and years about property insurance coverage and business interruption insurance and how that could possibly come into play to help out some of the tenants. So we're asking the tenants to make sure they reach out to their insurance agents and have this discussion with them and see if there's a claim to be made. That's probably a topic for another webinar at some point in the future about how property insurance ties into this. But for now, to answer your specific question, we're asking the tenants for copies of their policies and asking them to reach out to their insurance agents and their insurance professionals to see if this is even an option for them to try and get some coverage from a business interruption standpoint.
Right, even before we make concessions.
That's right. That's right. Yep.
So with all of the potential concessions that landlords may make with regard to COVID-19, what do you see the pros and cons are for making these types of adjustments?
Well, the pros are, you've got the ability to hopefully help the tenant work through a hard time. I mean, this is obviously, you've heard these cliches already. These are unprecedented times, et cetera, et cetera. And so the pro is to let them work through a hard time, and hopefully there's some viability there, and that we can all come out of this okay, or if not, not well, at least mitigate our damages. So that's the first thing, is working with tenants allows you to mitigate your exposure. But if it's a situation where the tenant, you don't think there's a viability, you don't think that no amount of rent abatement is going to help them, then there's a decision for the landlord to make. Because if you do give someone rent abatement for a couple months and it ends up not working out, is it really worth going through that process? So you got to ask that. Another con I would say is, and I mentioned this a few minutes ago, we are seeing a couple, and this is definitely not the majority of tenants, but there are a couple tenants who are trying to take advantage of the situation by asking for rent relief when either the request is excessive or the need is just not there yet. And so I would say that would be a con of just of agreeing to it. Another pro is, you really help build that foster or build that relationship with your tenant. I mean, you truly are now a partner with your tenant. And so at some point that may come back, or that should come back, whether it's karma or whether it comes back in the form of you getting concessions in your lease, that could come back to help you out. Which is another pro to this whole process is a lot of landlords, if they're giving concessions to their tenants from a rent perspective, they're combing through their leases to see if there are any clauses that they just want to get rid of or they don't like. I've had some landlords say, well, we don't want to take advantage of the situation, but I've had some other landlords say, well, look, now we're under the hood, and we're giving a concession for the tenant, and so we need something material in return. So that is a big exercise that landlords are doing right now, as far as reevaluating some of their lease provisions.
Can I ask you just to give me an idea of what some of those clauses might be, because that is a question. What should landlords be expecting to have to negotiate in the future?
Well, you mean as far as future rent relief, or?
Well, with lease clauses with regard to in rent, yes.
Yeah. So I've seen landlords, for example, take away provisions that typically landlords hate. For example, landlords hate rights of first refusal, rights of first offer. I'm seeing my landlord clients say, take all that out. Obviously, if your tenant has a termination right, a lot of our landlord clients are saying, well, get rid of that. If I'm going to give them a rent concession, I don't want them to exercise their termination right a year from now. The other super tenant friendly clauses that are baked in some of these leases are definitely being revisited right now. Mm-hmm. I'm having landlord clients, if there's a lease with a fixed renewal rate or a renewal option that the landlord does not like, I'm seeing a lot of landlords either revise those or take them out completely. One other thing I want to clarify, though, is one ask that's being made a lot is for abatement of operating expenses. to the extent that your lease allows you to pass through operating expenses. I've seen some landlords actually agree to that, and I think that could be a very slippery slope, because now it's costing you money as a landlord to actually have that tenant in there. So I would definitely be cautious about agreeing to any type of rent relief that includes reimbursement for expenses.
Yeah, it seems that right now, I mean, the prudent landlords are taking the steps to reduce operating costs so that, that need for abatement isn't there, and it keeps the, overall cost for the tenant low.
That's right. There's definitely a duty on landlords to, I mean, generally speaking, I think this is true, but especially now when occupancy is lower, but there's definitely an eye towards reducing costs. I will caution against one thing, however. Keep in mind that in every county in the Metroplex, even if you have some businesses that are shut down, none of the buildings are shut down.
Right.
The only time a building might get shut down is if there's some contamination and it's shut down on a temporary basis by the CDC or by another government regulatory body. But for the most part, buildings are remaining open even though the businesses are shut down. So what I've seen already is landlords, in an effort to reduce their expenses, have shut down all essential utilities, all essential services to the building. And what the tenants have argued is that, well, since you've shut the building down, I'm not going to pay rent. What we've even had other tenants argue is that by not allowing all the services to be provided to the tenant, that could be a breach of the covenant of quiet enjoyment that's in the lease. So, the real question, the big question for the property managers is, if I want to scale back and reduce expenses, how do I do so without cutting off essential services to the building? Because what I don't want to do is have a situation where the building is neglected, or something goes wrong with the asset and no one is out there to protect it or watch out for it. That's the first key. The other key is making sure you don't have a situation where the tenant comes back to you and argues that, well, since you shut off the elevators and the HVAC, I cannot actually occupy the premises. Yeah. So you got to be careful of that as well.
I have a question I want to ask you, but I want to jump back a little bit because I didn't ask it earlier. But what about charging tenants late fees right now?
Yeah. So so this is another question that has there's some civic implications here. Some people think, well, you should not charge the late fees because give everybody a break, cut them some slack. The other component of it says, well, there's a business side to it as well. There's a cost of money, and so the landlord has to pay the mortgage, landlord has to pay other expenses, and so if that money is late, the landlord is asking for it to be paid. And so I've seen both camps. I've seen landlords take both positions on it. I think probably the most practical approach I've seen is it depends on when the ask is made. For example, today's April 1st, and this morning I had I think 7 or 8 different requests from various landlord clients where the tenants called them today telling them that they're not going to be able to make April rent and wanting to waive the late fee. And the landlords are saying, well, haven't heard from you. We've reached out, haven't heard from you in a while, and now the tenants were waiting to the day the rent is due to actually reach out. And that's probably a situation where the landlords aren't being all that lenient. If the tenant's not going to be proactive, then typically the landlords are not going to be lenient with respect to the late fees. Which brings about another point. I know everyone is really busy right now, and this is definitely a trying time, but it's a very good idea to reach out to all of your tenants. If not from a relationship standpoint, but also from a legal standpoint, if the tenant does want to make some type of claim. But it's a good idea to proactively reach out to them, and definitely I would do so electronically, not physically, but and just check in on them and make sure that that they're able to pay rent and see if they have any questions. I would be cautious about asking them if they're wanting some type of rent relief. I wouldn't go that far. I would just check in with the tenants to just tell them that you're there for them. But I would not volunteer that information, or I wouldn't beg the question about whether or not they want some type of rent relief.
That's good. On another note, we have been hearing that, we want to flatten the curve so that we can get out of this COVID-19 situation, but we've also heard that there could be a breakout after the fall. Should we be making plans for that now?
Yeah, absolutely. Yeah, definitely. I think I think you definitely have to make plans for that. There's certainly I guess a boomerang effect or a second wave or whatever they're calling it that that we need to learn from. When I said a few minutes ago, never waste a crisis. This is one thing that we should look at again systemically and say, well, how do we prevent? What do we do if this ever happens again? And what I mean is, if there's ever another pandemic, or if COVID-19 comes back again, we have to be prepared for this to take these same measures again. So, and I guess the reason why people think it might come back is if things start getting better, quote unquote, over the next couple months, people start coming out of their homes. It's likely that since the virus it probably won't go away until there's some type of vaccine, it's likely that it just keeps coming back, and the next wave is just as bad or worse than this wave. And so we definitely have to plan ahead. There are a lot of experts in this field that are telling us that this may not be a one-time event, that this could either come back or continue to linger on for a long time. So I would absolutely prepare for this to happen again.
Okay. We talked about, tenants and what tenants are doing. Curious about protections for the landlord. I mean, I know that the landlords have protections in the lease. Is there anything governmentally or anything else insurance-wise? And I know we said insurance is for a good topic for a later date, but what are your thoughts?
Yeah, I would do this. I would do the same thing from a landlord's perspective, from the property management standpoint. To the extent you can go out and take advantage of some of the stimulus packages that are out there, by all means, I would definitely recommend looking into that. I would also recommend looking at the your property insurance policies to see if they have coverage for this. A lot of and again, this is a topic. This is a detailed topic for another day, and I'm happy to talk about it again. But the short answer to this question is, if the virus itself actually causes the building to shut down because somebody in the premises was infected, and the equipment and the property they were touching becomes contaminated, there's a pretty good chance that could be a covered claim under your insurance policy. And so, it depends on the type of insurance you have. It depends on the actual policy language, and it depends on specifically the facts. But nevertheless, to be proactive about this, the landlord should be pulling their property insurance policies, and the landlord and the property manager should be calling the insurance agents and professionals to specifically ask about this question, to see what scenarios would likely give rise to coverage. A lot of my law partners work in this field and do a lot of insurance work, and they're actually working with insurance holders, policy holders, and the insurance companies to give opinions about what type of scenarios would be covered by this, because there are going to be a lot of claims that come out of this. Some of those claims won't have any merit, but some may.
Yeah, that's good. I want to take a moment. I saw a couple of questions pop up, which we've addressed. But one question that came up, if you don't mind answering, is can tenants claim force majeure right now?
It's a good question. The tenant can only claim force majeure if their lease expressly allows them to claim force majeure. And most leases, this is a really generic statement, but most well-drafted landlord-friendly leases only give the landlord a force majeure right, okay? And so you have to look to see if the force majeure extends to the benefit of the tenant. So that's the first thing. Second thing you have to look for is, what does the force majeure cover? Some force majeure clauses only cover things like strikes, lockouts, shortage of equipment, things of that nature. So even if the tenant has the benefit of force majeure, you need to see if the language actually covers this specific issue. So for example, if the tenant has a force majeure clause for its benefit, and the tenant is a non-essential business and they are forced to shut down, and the force majeure language in their lease says that the tenant is excused from its obligations because of a government order or government shutdown, there's probably a good chance the tenant is can take advantage of that force majeure clause.
Okay.
But there's one other thing. A lot of the leases, the ones that we prepare, if we give the tenant a force majeure right, we exclude out certain things. For example, we exclude out their financial obligations under the lease. We say that they still have to carry insurance, and they still have to provide essential maintenance to the premises. So really, there's the short answer to your question is you got to look at the lease. But just because the lease has a force majeure clause, it may not give the tenant much protection.
Good answer. Thank you. I wanted to give a moment to see if there are any specific questions from our participants. And if you have a question, please go ahead and type that question in now as we wrap up.
As they're doing that, I'm breezing through my notes real quick to see if there's any other questions that were asked that I did not address. One, just to cover down on this, I think I mentioned this, but one thing I would be careful of is there's so many requests flying around and via email, and they may seem very informal. But this is going to be key, because this could really get a property manager in hot water. You have to be careful when you respond to an email or a text message from a tenant. Your emails and your text messages can definitely be a binding contract on the landlord. So for example, if you are having a back and forth conversation with a tenant and they're asking for rent relief, and if you don't clearly articulate your responses, or if you give vague answers, or if you don't properly respond to the question, if that could create a binding obligation on behalf of the landlord. So you've got to be super careful as you're communicating with these tenants specifically about this topic, about any topic really, but specifically about this topic, because the property managers are so pressured right now for so much going on. There's so many demands on your time right now that a lot of times, unfortunately, you don't have the opportunity to respond, take as much time as you want to respond to some of these questions. And so I've seen some situations where people are getting making mistakes because they've responded too quickly, and now the tenant is trying to hold them to something that they weren't willing to give. So please be mindful of that.
Yeah, that's a very good point. A question that came up, and it's a really good question: Can the pandemic be considered an act of God?
Yeah, it could be an act of God. I actually had a pretty heated debate with an opposing counsel a couple weeks ago. I was arguing that the pandemic was an act of God. She was arguing that it was an act of the devil. So I don't want to make this a biblical issue, but look, there's certainly, if you look at the legal definition of act of God, there's a pretty good argument based on how courts have addressed what an act of God is, that the pandemic is an act of God. Also, there's some catch-all language in the force majeure clauses that talk about anything else beyond the control of the landlord or beyond the control of the tenant. and there's definitely some good precedent that a pandemic would be beyond the control of the landlord or tenant. So that would probably also fall into the same category of act of God.
Okay, good to know. Well, Tony, we're coming toward the end of our session today. Is there any summary that you'd like to give us, or any words of wisdom?
The words of wisdom, I would say same thing I said last Friday at the conclusion of the webinar. I would keep calm, and we will all get through this. You got to just keep in mind, we have to be smart about this, not only from a human side, not only from a health and safety side, but also from a business perspective. We're so rushed, and there seems like there's such an emergency to handle all these problems. But what we don't want to do is lead that frantic pace to have us make bad decisions. So we have to be careful about making good decisions, not only from a health and safety standpoint, but also from a business standpoint. Awesome.
Thank you, Tony. I think with your input and your help today, we are going to be able to make a lot of better decisions going forward.
Well, good. That's good. Thank you.
All right. Well, thank you everyone for joining us today. And to everybody who submitted questions, again, we're not able to answer all of the questions, but we do encourage you to reach out to your legal counsel if you need assistance. I also want to thank Tony Barbieri of Kessler Collins for his time and expertise. And then many thanks to our BOMA Greater Dallas Keystone partners for their support. Again, America's Corporate Building Maintenance, Blackmon Mooring, Britton, CertaPro Panniers of Far North Texas, Citywide Building Services, the Flynn Companies, Reef Parking, Property Paving, Texas Roof Management, and United Mechanical. Finally, we know there's so much information that you need, so we'll continue to hold a weekly webinar on topics related to COVID-19. In fact, this Friday, April 3rd at 11:30 a.m., we'll be hosting a webinar titled Managing Stress During a Stressful Time, where Dr. Stevie Don, a BOMA Greater Dallas favorite, will be our speaker. Registration will be available at bomadallas.org. And until then, stay healthy, be safe, and good day.